I'll wait for you guys. And good? Okay. Well, good afternoon. Today we have a three-part announcement, the first two parts of which are updates about our fight against the opioid epidemic. First, yesterday we had some great news in the first court case that we filed. As many of you will recall, we filed suit against Endo Pharmaceuticals in November of last year. Our first opioid lawsuit alleged that Endo unlawfully built a market for the chronic use of their opioid drugs, specifically the highly addictive Opana ER. Our suit claimed and claims that Endo targeted Kentucky veterans in promoting this drug, which led to the death of Emily Walden's son, TJ, in 2012. We also believe that Endo's shirking of the abuse of its drug also led to a surge of HIV cases in Scott County, Indiana in 2015 and put more than 50 Kentucky counties at risk for a similar outbreak. This case, which is proceeding in Franklin Circuit Court, was subject to a motion to dismiss by Endo. I argued against that motion personally, along with a number of other attorneys. During that argument, Endo claimed that they had no responsibility that we Kentuckians did this to ourselves. It was, in a word, offensive. Yesterday, Judge Wingate denied Endo's motion to dismiss in full, meaning our entire case as filed against Endo will proceed into discovery, where we will continue to work to hold them accountable. This is a first important victory in the first case filed against an opioid manufacturer. Second announcement, we received additional good news today in the second case we filed. That case against McKesson was filed in January of this year. It will be returning to Franklin Circuit Court from the multi-district litigation panel after the company agreed to the remand. Our suit against McKesson alleges unfair, misleading, and deceptive business practices for excessively distributing opioids, particularly in the rural counties in eastern Kentucky, and for failing to report to the DEA these incredibly large volumes. I want to remind you of some of the numbers from that suit. From January 1st, 2010 to December 31st, 2016, McKesson distributed 18,434,834 doses of opioids in Floyd County, Kentucky alone. Based on the population of Floyd County, that amounts to 477 opioid pills for every man, woman, and child. That case, along with Endo, will now be proceeding in a Kentucky state court, here Franklin Circuit Court, where we will continue to seek justice. Because these companies knew how dangerous their drugs are. They knew that countless Kentuckians would become addicted, and they flooded our state with pills anyways. Both of those updates are very good news. And now for our third announcement, and the main reason we're here today. From day one, I've dedicated myself as Attorney General and this office to finding solutions for Kentucky's devastating opioid epidemic. In the past 2 years, this office has pursued heroin and fentanyl dealers. We've announced a Dropbox partnership with CVS. We've launched the Kentucky Opioid Disposal Program aimed at cleaning out every single medicine cabinet across Kentucky. We've cracked down on rogue Suboxone clinics, and we've investigated rogue doctors. We were recently a part of the national takedown announced by the Department of Justice. We've hosted numerous community drug forums and opioid disposal events all across Kentucky, and thus far, we have filed 6 lawsuits against opioid manufacturers and distributors for fueling this epidemic. These 6 lawsuits are against Endo Pharmaceuticals, AmerisourceBergen, Janssen, Cardinal Health, McKesson, and Walgreens. I am proud of the work that our team, which has worked so hard, has done. But we will not stop fighting for our families. We will not stop seeking justice. And we will not be silent when this epidemic kills 4 Kentuckians day after day after day. Today I'm announcing that we are filing suit against Mallinckrodt, a St. Louis-based pharmaceutical company and one of the earliest producers of morphine and codeine. In fact, for years the company was synonymous with the addictive painkillers that it sold. People would ask their pharmacist for their Mallinckrodts. Mallinckrodt sold and promoted their opioids by falsely claiming the drugs could be taken in higher doses without disclosing the additional risk of addiction. While an agreement with the DEA currently prevents us from releasing a total number of doses sent to Kentucky, I can tell you the number is egregious. And if that number from the DEA is correct, it would be sufficient to cause the addiction of every man, woman, and child living in Kentucky. Mallinckrodt promoted its opioids by consistently underplaying the risk of addiction and pushed these and other deceptive messages to Kentucky prescribers through patient guidelines, websites, marketing materials, and their own sales representatives who would personally visit these offices. The company has claimed without evidence that long-term opioid use, quote, helps enable patients to stay in the workplace, enjoy interactions with family and friends, and remain a member of society. Those aren't my words. They come straight from the company's website. The company directed front groups to promote opioid use and combat efforts to restrict opioid prescribing, and they failed to report suspicious orders of opioids coming into Kentucky. They had a duty to help prevent this massive addiction that we are dealing with, and they failed to perform that duty. They knew what they were doing. They made the conscious decision to put their profits in front of the health of our people, to allow countless Kentuckians to fall into addiction while they made money month after month after month. Last year alone, they generated $3 billion in revenues while our communities suffered. By comparison, the $35 million they agreed to pay the federal government for violating federal reporting laws does not seem like that much. If a punishment is supposed to fit a crime, and it is supposed to correct behavior, we must do more. And because of their violation that they've admitted, they were required to enter into an accountability agreement with the DEA. They willfully violated Kentucky law by failing to report suspicious orders. We're listening to Kentuckians who have lost their loved ones. They are seeking justice. That's why we are filing this suit today in Madison County Circuit Court, a community that has also been hit so hard by this drug epidemic. We are making these companies come to our communities to explain to a jury of our people how they took these actions, and I believe that our Kentuckians, our families, will hold them accountable. I keep my promises. I will continue to put Kentucky families first. These companies have a duty to help us find a solution to this drug epidemic. And if they won't do it willingly, we'll drag every single one of them into a Kentucky court of law. I'm happy to take any questions.
Why does the DEA not want you to say how many doses would that be public?
I believe it should be. So the numbers, the data is called the ARCOS data, ARCOS. And currently, we spent months working to get this from the DEA, and we finally got it, but only under an agreement that if we use the numbers, we'd file it under seal. I believe those numbers should be public. There are several news organizations that have sued and I believe have an upcoming hearing in front of the multi-district litigation panel asking that judge to make that data public. It should be.
Well, I mean, some of your other lawsuits that filed it, as you just said earlier.
In the earlier lawsuits, our numbers were based on what we could secure from Medicaid claims, as well as the total market share, looking at the total amount of doses we believe coming in. We haven't been able to share any ARCOS data thus far, but I can tell you the moment that this office is allowed to share it, we want everyone to see all of it, and I believe you as the media should be able to see it.
And I know you're not the DEA. So
I'm not.
Sorry to keep asking you questions about it.
That's okay.
Did they give a reason? Like, was it proprietary information or law enforcement secrets?
I don't want to give their reasons. They'll be making it in front of the judge up there. I believe there's been some coverage that you could probably pull quotes from them. But let me again say that this data should be public, and the numbers in this lawsuit are some of the most egregious that I have seen. They would stun any and every Kentuckian, and again, there are enough doses in that data to cause the addiction of every man, woman, and child in Kentucky.
Why Madison County? What was the file there?
Well, I believe that every community that has been hit by this drug epidemic deserves to have one of these cases filed in their courts. That no matter where you live in Kentucky, you ought to experience some of the justice and accountability that we are bringing to these companies. Madison County has been hit hard by the opioid epidemic. They saw a significant amount of heroin. They have a wonderful group of law enforcement there, and city police, and in the sheriff's office, and in the KSP post that's out there. When we look at filing these, we look at areas that have been hit specifically hard, and Madison County deserved to have one of these filed in their community, just like every other community does.
When you file these suits, are you just seeking payment to the state, or are you seeking like class action steps?
We-
Get monetary payments?
Well, we can't seek medical damages for victims as an office. So what we are seeking are penalties for violating the Consumer Protection Act. We are seeking abatement of what's called a nuisance, which could come in a number of different forms. It's basically a court order that forces them to help us address this drug epidemic, which could also come in monetary or other forms. We're seeking injunctive relief to keep this from continuing to happen. While there have been some steps that have been taken, these companies are still making billions on this product that is still flowing into the state at way too high of a level. So we're seeking ultimately to make these companies part of the solution, and they're unwilling. But we believe a Kentucky jury and a Kentucky judge that it's in front of is going to make them accountable and part of that solution.
General, has it been determined if it's more effective for an individual state like Kentucky to sue a manufacturer, or if states go in together and sue?
Well, I believe in controlling our own destiny. You know, the multi-district litigation that's going on right now, the first couple cases that it's going to push forward aren't connected to Kentucky. They don't have, I believe, the same level of damages. Some are from Ohio, which has also been hit. But when you look at how hard we've been hit, I can't agree to be a part of something that might come up with an overall settlement based on population. That would not be fair to Kentucky, where we've been hit so much harder. And I don't believe that Kentuckians who've been harmed by these products and by these companies ought to have their justice decided by a judge in a different state. Now, I think he is a good judge, and he's been fair at the meetings we've attended, but I believe in my heart, and I believe Kentuckians do too, that these cases should be tried here. And we're going to have at least two that we know are moving forward with it. And now the Indo case will be in full-blown discovery.
What's the status of the lawsuit challenging the contract between the law firms?
Right. We secured a judgment by the Franklin Circuit Court saying we did everything right. When we found out that the Conway administration had let that contract expire, but work had continued and a settlement had been reached, that we went to the Finance Cabinet and said, here's the entire situation, what should we do? The Finance Cabinet gave us the advice. This is the Governor's Finance Cabinet. We followed that advice, and then later he decided to sue us over doing what his Finance Cabinet told us to do. Judge Wingate said that our actions were appropriate, and now the Governor has appealed that order.
I meant, well, I didn't mean that one. I meant the other one. You hired a couple of law firms to help you file all this lawsuit.
Okay.
I think didn't the finance
Yes.
challenge that?
Yeah, we also won that in Franklin Circuit Court with the court ruling that one constitutional officer can't control the actions of the other. And in this instance, the Finance Cabinet Secretary was trying to use his discretion to simply cancel our contracts. And that ought to offend Kentuckians. They want us to pursue these opioid manufacturers and distributors, and for some reason, the Governor's office is intent on stopping us. So we went to court because we believe that we have to seek justice for our families based on these companies' actions. The trial court ruled that our contracts were legal, that the finance cabinet can't do what they've done, and that's being appealed by the governor's office too.
If it's still ongoing, if there's appeals.
They have appealed.
How much of the work in these cases is being done by your attorneys in-house, and how much is being done by the outside counsel?
Well, it is a team effort, but we always maintain control. And I think you see that by the fact that I was at the endo argument myself, and I started our argument against that motion to dismiss. We have our people at every major motion. We have our people at every deposition. We are intimately involved. But what those outside counsel do, and they do them in the other cases too, is ensure that Kentuckians don't have to pay the hundreds of thousands of dollars of costs. You know, if we get 100 million documents, you got to house that on an online platform. It's got to be searchable. You've got to have the extra bodies to do those searches. That would end up costing the state dollars that they don't have and they don't budget to us. And so outside counsel provides additional expertise and fronts all of our costs. And they never get paid a tax dollar. They just get paid a part of a winning if there's a win.
You said earlier that you wanted to bring these companies to the state to face a jury of our,
Yes.
our peers. So does that mean that you're going for a trial with every one of these, or would you be agreeable to a settlement if certain one?
If any company decides that they want to be a part of the solution, we want to work with them. I mean, we recently announced that Dropbox initiative with CVS. It's a great initiative. It has on every 24-hour CVS, there's now a Dropbox where you can drop off any amount of unused prescription drugs, including any amount of opioids, and the company will dispose of it on their dime. Communities that have one of those 24-hour CVSs ought to be using them. That's an example of a company doing at least one thing to work to be a part of the solution. And any that comes in that says we want to make things right, we'll certainly talk with them.